I'll just give it about 30 seconds. All right. Hello, everyone, and welcome to today's webinar. I'd like to start by passing over to our Sex Discrimination Commissioner, Dr. Anna Cody, to lead us in an acknowledgement of country.
Thanks very much, Caitlin. And I'd like to acknowledge the traditional owners of the land that I'm on and that we at the Commission are on, and that is the Gadigal people of the Eora Nation. I pay my respects to elders past and present, and I also recognise and acknowledge the Indigenous people who are participating in this webinar and welcome you to this webinar.
Great, thank you, Anna. So again, welcome everyone, and thank you for making the time to come today. There's a lot of information that's about to be thrown at you, but this session is being recorded and will be published to the Commission's website. Thank you to everyone who emailed in a question for the webinar today. We have based parts of the presentation on the inquiries we've received, so hopefully we answer them. I'm going to start today with a short overview of today's webinar, what we'll be going through, and introductions to our wonderful panelists. So first, we have Australia's Sex Discrimination Commissioner, Dr. Anna Cody, who will be speaking about the introduction of the positive duty and why it matters. Part 2, led by Ella Kucherova, the Legal Director of the Positive Duty Compliance Enforcement Team, will focus on an overview of the positive duty and the Commission's resources and compliance framework. And Part 3, led by the Director of the Positive Duty Enforcement and Compliance Team, Tanya Murphy, will focus on the Commission's approach to enforcement and compliance. So I'll turn to Commissioner Cody to ask our first question. Commissioner Cody, can you tell us, what is the positive duty and why has it been introduced?
Thanks, Caitlin. So the Australian Human Rights Commission in 2020 conducted a national inquiry into sexual harassment in workplaces and released a report, Respect at Work. And what it found is that sexual harassment is pervasive, with over 1 in 3 workers experiencing that, and also a particularly high incidence for LGBTQI+ workers and First Nations workers. We then conducted a survey in 2022, and that national survey found that in the previous 5 years, women, 41% of women, and non-binary workers, up to 67%, had reported experiencing sexual harassment at higher rates than men, and that also people with an intersex variation were more likely to report experiencing workplace sexual harassment. And then also people who identified as gay, bisexual, lesbian, or another sexual orientation also experienced much higher rates of sexual harassment. We also know that people living with disability also experienced higher rates, 48%. So additionally, there's been another research report published which showed that 701 migrant women had also experienced higher rates, so almost half of culturally, racially marginalised women experience sexual harassment at that higher rate. And that's particularly exacerbated and of even greater concern for those who are on temporary visas or who are in precarious work situation. So all of that demonstrated the extent of the issue that we were facing. But at the same time, what we also documented was that only 18% of workers who have experienced, so we've heard about the very extensive rates of sexual harassment, but only 18% of people who'd actually experienced it complained about it. And what we've realised is that our previous laws were inadequate for actually stopping sexual harassment, and that the rate wasn't being impacted by our laws to actually stop the rate of sexual harassment. And that's because it put far too heavy a burden on individuals to make complaints and uphold equality in the workplace. So what we realised was that what we needed was a change to the law to introduce a positive duty. And that positive duty sits on employers and organisations And it means that employers have now a responsibility to eliminate, as far as possible, unlawful conduct rather than just responding once it's happened. So it takes that responsibility off the individuals who already have the burden of having experienced it and having to deal with it on their own, and places that responsibility on employers. So people can still complain individually about what has happened to them, but the positive duty is a systemic change, and it puts that preventive, proactive approach and that responsibility on our employers.
Wonderful. Thank you, Commissioner Cody. Now, can you tell us, in regards to the positive duty, what is the importance of addressing a spectrum of unlawful behaviours in the workplace and not just sexual harassment?
So it is really important to know that the positive duty covers more than sexual harassment. And perhaps just a reminder of what sexual harassment is. What it is unwanted sexual conduct. So examples such as comments, propositioning someone for sex, sending text messages that are of a sexually explicit nature, staring sexually at someone, making gestures, sending pornographic images to someone over mobile phone, or even sexual touching and sexual assault. So that's sexual harassment. But the positive duty also includes sex discrimination, sex-based harassment, and also having a hostile work environment on the basis of sex. And it also includes victimisation. And the reason why that's those 5 unlawful conducts is with the aim of achieving workplaces that are equal on the basis of sex. So the overarching goal is to achieve sex equality. So what we realise as well is that rather than just experiencing sexual harassment, what we found through the Respect at Work research was that people often have that combination, unfortunately, of conduct and of their experience. So people talk to us about experiencing being sexually harassed, but also that sex-based harassment, or then once they've made a complaint, being victimised after having made a complaint. So that's why we have those 5 forms of unlawful conduct included within positive duty. So for an example of someone who's been subjected to a workplace that's hostile on the ground of sex, that might include a display of pornography in the workplace, or comments such as women shouldn't be doing certain jobs in the workplace, or they belong making cups of tea rather than analysing a research report. Or another example would be that men aren't suited to looking after older people or children because they aren't as good as caring as women. So those sorts of comments would be creating a hostile workplace environment on the basis of sex, and that's now covered by the positive duty. We've got some great resources, which the later speakers will refer to, including an information guide, which gives some further examples about what's covered by that.
Thank you, Commissioner Cody. And finally, what kind of long-term impact can the implementation of the positive duty have on Australian workplaces?
So as I've mentioned, the aim of this law is gender equality and ensuring that we can have fair, inclusive workplaces for women. So the overall aim is to create inclusive, equal workplaces, and that's because it is absolutely essential to improve the way in which our society works and our employment situations work as well. It also includes fundamental principles such as consulting with staff and including intersectionality so that we can reach a really full understanding of equality. We know that safe and respectful workplaces advance gender equality and that that's good for business. And if people feel safe and respected at work, then they're generally more productive as well. And also organisations have a range of benefits. We know that gender equality improves national productivity and economic growth. We know that it makes a significant impact on economic growth. And KPMG had recently done a report which projected that if we halved the labour force participation gap between men and women, then Australia's annual GDP would increase by 60 billion in just 20 years. Another benefit is organisational performance. A diverse and inclusive workforce increases innovation, productivity, creativity. We know that those companies who have who are in the top quarter for gender diversity on their executive and leadership teams are 21% more likely to experience above average profitability. So it affects the bottom line, and that then impacts on investors' interest in investing in those companies. Gender equality also means that you can attract better talent. When workplaces are equally appealing to women and men, organisations have access to a broader talent pool. Many employees value positive workplaces that have gender equality, and so those workplaces will be more likely to attract that broader range of people. Also, retention. Employees are more likely to stay with an organisation that's got a diverse environment. And that certainly benefits the workplace, because where there's high staff turnover, then there's that loss of specialist knowledge and productivity. And from other reports that have done, we know that the Australian economy loses over 3 billion every year in lost productivity because of this. Finally, reputation. We know that equality improves organisations' reputation and again, impacts on those other factors that I've just discussed. So to eliminate sex discrimination does include measures which ensure that women can participate fully in the workplace and in leadership across the workplace. So that's good for our businesses, our society, and it will create a society which is more equal, in which we can all participate regardless of our gender, and we're valued for our contributions.
Wonderful. Thank you so much, Commissioner Cody. We're moving into part 2 now, the overview of the positive duty and the Commission's resources. The objective and the focus of this section is to gain insights into the positive duty framework and discover valuable resources provided by the Commission to support organisations in creating inclusive and respectful workplaces. So I'll pass over to Ella now to lead us in this section.
Thank you, Caitlin. One of the most important pieces of information that we are hoping to communicate in today's webinar is that the Commission has published a set of resources to help organisations and businesses understand and comply with the positive duty in the Sex Discrimination Act. So these resources were produced following a significant consultation process, and they are targeted at different audiences. So the guidelines themselves are the Commission's most comprehensive resource on how to comply with the positive duty. So they're likely to be very relevant for senior leaders in an organisation, HR professionals, lawyers, as well as anyone looking for more detailed information and a wide range of practical example actions. And it is the guidelines that the Commission will be using when assessing compliance with the positive duty. As you've already heard today, the positive duty attaches to certain forms of conduct that are made unlawful by the Sex Discrimination Act. And again, one of the key messages that the Commission is really trying to emphasise in all of its positive duty communications is that it covers more than just sexual harassment. So the information guide is an educative companion piece to the guidelines that explains the different forms of unlawful conduct covered by the positive duty, as well as their drivers, risk factors, and impacts. I will touch upon some of these briefly today, but given time constraints, if you're looking for further information, it can be found in the information guide. In terms of other resources, we also have the quick guide, which is a summary of the guidelines and the information guide, and the resource for small business. So this provides the simplest explanation of the positive duty and actions that can be taken to meet it. So it's certainly a very good place to start if you're looking for an introduction or a general overview. The Commission has also published fact sheets relating to the positive duty, including ones on effective education and training and person-centred and trauma-informed approaches to safe and respectful workplaces. So this initial suite of resources is available on the Commission's website now, and it is expected that more will be added over time. So it's worth checking back periodically, although we will of course notify through our usual channels, including our newsletter and social media, when significant new resources are added. We have heard from the Sex Commission Sex Discrimination Commissioner today about the positive duty, its origins and why it matters. And now I'd just like to zoom in a little and explain its legal definition. The positive duty requires employers and persons conducting a business or undertaking to take reasonable and proportionate measures to eliminate as far as possible certain forms of unlawful conduct. So these are discrimination on the ground of sex in a work context. So that's sex discrimination in both its direct and indirect forms, sexual harassment in connection with work, sex-based harassment in connection with work, conduct that creates a hostile workplace environment on the ground of sex, and related acts of victimisation. I will explain later who falls within the definition of an employer or a person conducting a business or undertaking, noting that I will sometimes use these terms and the terms organisations and businesses or duty holders interchangeably. So as you can see, the positive duty is focused on eliminating unlawful behaviours in the context of work, workplaces and working relationships. So it aims to create systemic change by preventing unlawful conduct from happening in the first place, rather than simply reacting after it has already occurred and often caused harm. So the positive duty requires organisations and businesses to be proactive and to take reasonable steps to eliminate the relevant unlawful conduct as far as possible. So simply responding to individual reports as they arise is not enough. And as we'll see in the third part of this webinar, organisations and businesses can now also be held accountable, even if no one makes an individual complaint under the Sex Discrimination Act. Again, as the Sex Discrimination Commissioner referred to, in terms of the conduct covered by the positive duty, two forms are relatively new as standalone provisions in the Sex Discrimination Act. So these are the provisions relating to sex-based harassment, which were introduced in 2021, and the hostile workplace environment provisions, which were introduced last year in 2022. And as they are, I think, some of the least understood provisions covered by the positive duty, I will just address them briefly. As many people know, sexual harassment involves unwelcome conduct of a sexual nature, whereas sex-based harassment and hostile workplace environment provisions involve conduct that might be sexist or misogynistic or misandrist in nature, but not necessarily sexual. So misogynistic here meaning strongly prejudiced against women, and misandrist meaning strongly prejudiced against men. Sort of broadly, and recognising that these behaviours often appear together and overlap, we can still make some distinction between conduct that is of a sexual nature and conduct that is of a sexist nature. And now both forms of conduct are explicitly unlawful under the Sex Discrimination Act if they amount to sexual harassment, sex-based harassment, or conduct creating a hostile workplace environment. And when connected to work, they are covered by the positive duty. The positive duty also covers acts of victimisation that relate to other conduct covered by the positive duty, including making an allegation that an organisation or business is not complying with the positive duty. So in general terms, victimisation is treating or threatening to treat someone badly or subjecting them to a detriment because they have reported unlawful behaviours or asserted their rights under the law or helped someone else to do so. Now, as I mentioned earlier, the positive duty applies to any person conducting a business or undertaking, a PCBU, or an employer, as these terms are defined in the Sex Discrimination Act. Now, the definition of a PCBU in the Sex Discrimination Act is consistent with the one in the Federal Work Health and Safety Act. PCBU is a term that many people are familiar with because it does come from work health and safety law. So PCBU has a broad definition, which includes sole traders and the self-employed, small, medium, large businesses, partnerships, as well as government. So most organisations and businesses are subject to the positive duty in the Sex Discrimination Act. A notable exception is an entirely volunteer association that does not employ a single person. So under the positive duty, employers and PCBUs have obligations, including in relation to their employees and workers. And it's important to note here that the definition of a worker includes unpaid workplace participants such as work experience students, interns, and volunteers. Employers and PCBUs must take reasonable and proportionate measures to eliminate, as far as possible, relevant unlawful conduct from being engaged in by themselves, by their employees, workers, and agents, and in some cases by third parties, such as customers, clients, and members of the public, towards their employees and workers. So the extension of the positive duty to the conduct of third parties recognises the important role that organisations and businesses can play in protecting their workers from unlawful behaviour and providing safe, respectful and inclusive workplaces. And this is, of course, because third parties can pose a significant risk to employees and workers. A simple example of this would be bar staff being subject to demeaning and sexist comments by patrons at the pub. So the positive duty extends to cover this third-party conduct, and duty holders are obliged to take reasonable steps to eliminate it. Now, while the Sex Discrimination Act requires all duty holders to take proactive steps to eliminate the unlawful conduct covered by the positive duty, it recognises that compliance will look different for different organisations and businesses. And this is because what is reasonable and proportionate for one organisation may not be for another. So in determining compliance, the Sex Discrimination Act requires the Commission and the courts to consider the size, nature and circumstances of the duty holder's business or undertaking, the duty holder's resources, financial or otherwise, the practicability and the cost of the measures to eliminate the conduct, and any other relevant matter. And it's made clear here that any other relevant matter can include whether an organisation or business has followed the Commission's guidelines. The guidelines set out 4 guiding principles and 7 standards that the Commission expects duty holders to meet to satisfy the positive duty. So this provides an end-to-end framework for prevention and response, which duty holders can then tailor to their own circumstances and workforces. So the guiding principles are informed by a human rights-based approach, and they should guide the decisions that an organisation makes when implementing the 7 standards. The full guiding principles are set out in the guidelines, but in summary, an approach should involve consultation so that any actions taken are informed by those affected or potentially affected by the relevant unlawful conduct. They should advance gender equality so that people of all genders have equal rights, rewards, opportunities and resources. Should acknowledge intersectionality, recognising that different aspects of a person's identity intersect and impact upon one another, and that a person's experience of unlawful conduct can be compounded by other forms of inequality. And be person-centred and trauma-informed, ensuring that workplace systems, policies and practices support people's safety, dignity and avoid causing further harm. So the 7 standards are based on the prevention and response framework in the Respect at Work report. And again, the Commission expects all duty holders to meet these standards while recognising that the way in which they do so is likely to differ. So these are the 7 standards. You'll see that each standard is outcome focused and made up of constituent parts. I don't have time to go through each of the standards today, but they're based around the areas of leadership, culture, knowledge, risk management, support, reporting and response, and monitoring, evaluation and transparency. So for each of these 7 standards, the guidelines provide information about why they are important and examples of practical actions that duty holders can take to meet them. So the Commission has made clear in the guidelines that an organisation will not need to implement all of the practical actions listed in the guidelines in order to satisfy the positive duty. There are a lot of examples given, and this was in response to strong feedback during the consultation process that duty holders wanted concrete examples of practical things that they could do to try and eliminate the relevant unlawful conduct in their workplaces. The standards are also interrelated. In many cases, an action taken to meet one standard may also assist in meeting one or more of the other standards. And as Tanya will discuss, compliance will always be assessed holistically and depend on what is reasonable in the circumstances of a particular duty holder. So taking the first standard, leadership, as an example, we can see how the outcomes in the standards align with the practical example actions provided in the guidelines to help organisations and businesses meet that standard. So for instance, the first part of the leadership standard is that senior leaders understand their obligations under the Sex Discrimination Act and have up-to-date knowledge about relevant unlawful conduct. And one of the ways that duty holders can meet that standard is by ensuring that their senior leaders read the guidelines or attend education sessions on relevant laws and their rights and responsibilities. So for each of the standards, you have the outcomes and then examples of possible actions to meet that standard. In implementing the standards, the Commission has also made clear that it doesn't want duty holders to feel constrained or restricted by the examples given in the guidelines. We recognise that individual organisations and businesses are often best placed to understand the actions that will make a positive difference for their particular workforces and to drive meaningful change. So as this quote suggests, the guidelines strongly encourage innovation, creativity, the development of bold strategies to achieve substantive equality and to foster positive workplace cultures. So we are hopeful that the introduction of a positive duty into federal discrimination law will mark a true turning point in how we understand and address sexual harassment, sex-based harassment, and sex discrimination in the workplace. There's a real opportunity here to drive leading practice and to be champions of these issues in your own workplaces. So thank you all for attending today, and I'll hand back to Caitlin to continue.
Great, thank you so much, Ella. We have received a follow-up question. Can you tell us, how does the positive duty in the Sex Discrimination Act interact with other legal frameworks?
Yeah, it's a great question and it's a very important one. The behaviours that constitute the relevant unlawful conduct covered by the positive duty in the Sex Discrimination Act are addressed under different laws in Australia at both the state and territory and federal level, and they are regulated by a number of legal frameworks. So this might include obligations under work health and safety laws, workplace or industrial relations laws such as the Fair Work Act, or obligations under state and territory anti-discrimination laws, including those with similar positive duties. Our guidelines and this webinar focus on what the Commission expects organisations and businesses to do to comply with the positive duty in the Sex Discrimination Act. So in practical terms, the actions and measures that a duty holder takes in this context are likely to be very similar to the actions that they are required to take to comply with other legal frameworks, such as WHS laws, and the same preventative action may be used as evidence of compliance with multiple legal duties. However, the laws they're not identical. And so we strongly encourage organisations and businesses to consult the specific guidance material put out by other government agencies and regulators about their own laws and frameworks. So for example, Safe Work Australia and WHS regulators have produced some excellent guidance about what organisations must do to satisfy their WHS duties in relation to sexual harassment. And we're available we've provided links to this material in our guidelines. Thank you.
Great, thank you so much, Ella. That was great. We're now moving on to part 3 of today's webinar. So the Commission's approach to compliance and enforcement, which will be led by Tanya Murphy, the Director of the Positive Duty Enforcement and Compliance team. So the objective of this section is to understand the nuances of the recently introduced compliance and enforcement policy by the Commission and its implications for organisations and businesses working to meet compliance. Thank you, Tanya.
Thanks, Caitlin. So we've now heard about why the positive duty legislation was introduced, what the positive duty is, what our expectations are concerning meeting our 7 standards, and what resources are available to you. But what does this all mean to you if you are a business or an organisation? And how is the Commission going to approach regulating you and inquiring into compliance with the positive duty? Well, the answers to these questions are contained within the Commission's Positive Duty Compliance and Enforcement Policy and also our Positive Duty Guidelines. As Ella already mentioned, the guidelines will be used by the Commission in assessing compliance with the positive duty. But I'm now going to focus on the Commission's Compliance and Enforcement Policy, which provides clear information about the Commission's approach in performing its functions concerning the positive duty. So again, when you hear me talk about you or organisations and businesses, know that I'm referring to employers and persons conducting a business or undertaking. So what are the functions of the Commission with respect to the positive duty? So when looking at how the Commission will utilise its powers, we need to first understand the functions of the Commission with respect to the positive duty. So the Commission has compliance and enforcement functions to inquire into and ensure compliance with the positive duty. And the Commission also has statutory functions to promote understanding and acceptance and public discussion of the positive duty, and to undertake educational programs and research into the positive duty. So you can see from the functions conferred on the Commission, its role is focused on promotion, research, education, best practice, and to facilitate proactive and voluntary compliance. This is important as it helps us to understand the Commission's approach to compliance and enforcement with respect to the positive duty and how the Commission will utilise its new powers. So what are the Commission's new powers? As we've already touched on, the Commission's powers to regulate the positive duty came into effect today, and the Commission now has the power to inquire into compliance, make findings of non-compliance, issue compliance notices that can be enforced by courts, and enter into enforceable undertakings with organisations and businesses with respect to the positive duty. So how has the Commission responded to its new powers? Well, in order to support the functions we just discussed, and in response to the new positive duty regulatory powers, the Commission has created a positive duty team. So the positive duty team is a multidisciplinary team whose purpose is to support the Commission's enforcement and statutory functions with respect to the positive duty, to support meaningful cultural change towards safer, respectful and more equitable workplaces in Australia, and to ensure in compliance by organisations and businesses under the Sex Discrimination Act in relation to the positive duty. So how can you provide information to the Commission about the positive duty? So the Commission has created a web page called the Positive Duty Online Form and Resources. This web page explains how the Commission will regulate the positive duty, and it links to the Commission's compliance and enforcement policy and also our online positive duty form. The online positive duty form is where you can provide information about concerns with an organisation or business complying with the positive duty. This web page also provides information about what the Commission will do with your information and what the Commission won't do with your information after you complete the online form. Now, the positive duty online form is not the same as making a complaint. The online form is providing information. There is, however, a link on the web page which will direct you to the complaints page. And the complaints page provides further information about how to make a complaint concerning discrimination and human rights. So how will the Commission approach regulation of the positive duty? So the Australian Human Rights Commission Act gives the Commission a discretion about how it exercises its compliance and enforcement functions. The Commission is committed to using its resources strategically to provide the greatest benefit for the community and impact for meaningful cultural change. A leading objective of the Commission is to help organisations or businesses to improve their own practices through voluntary compliance measures. However, the Commission does have a suite of compliance and enforcement powers that we can utilise if efforts to achieve voluntary compliance are not successful. I will discuss these coercive powers shortly. So this visual aid helps to demonstrate the Commission's approach to regulating compliance with the positive duty, with voluntary compliance being our preferred initial approach. But again, remembering that the Commission has compliance and enforcement powers that can be utilised if voluntary compliance is unsuccessful. This is depicted here, where you can see the Commission's level of regulatory intervention. It may increase as cooperation from an organisation or business may decrease. So how does the Commission decide which organisations or businesses to engage with? So the Commission isn't able to pursue all matters that come to its attention. So in deciding whether to engage in compliance and enforcement activities, the Commission will consider such things as, but not limited to, is it within our jurisdiction? Is it in the public interest? What are the Commission's resources? Will it impact on other government agencies and regulators? What is the nature and seriousness of the non-compliance? Does it involve vulnerable workers within the community? What is the compliance posture and history of the organisation or business? And what are the likelihood of activities having a broad impact on meaningful cultural or systemic change? So when may the Commission decide to seek voluntary compliance? Well, as I've already advised, the Commission's preferred regulatory approach is to work collaboratively with organisations or businesses to assist them to achieve voluntary compliance with the positive duty. If the Commission identifies areas of non-compliance, the Commission may first offer to work with the organisation or business on a voluntary compliance basis, where appropriate, to support them to meet their legal obligations. The fact that an organisation or business has engaged cooperatively with the Commission will be considered when deciding whether to take enforcement action and which enforcement action to take. So how can the Commission commence an inquiry? The Australian Human Rights Commission Act gives the Commission a discretion about what and how it chooses to conduct its inquiries. The Commission can commence an inquiry when it reasonably suspects that an organisation or business is not complying with its positive duty obligations. So what is reasonable suspicion? Reasonable suspicion requires less than a reasonable belief, but more than a possibility. The reasonableness of any suspicion will be judged in light of the facts available to the Commission at the time. So how does the Commission form a reasonable suspicion? Well, we can form a reasonable suspicion in a variety of ways, for example, through environmental scanning, research, academic literature, information or advice from other government agencies or regulators, information received from impacted individuals, information obtained in the course of performing our other functions, including complaint handling, engagement with or information from stakeholders, unions or workers' representatives, and of course through the media and social media. So what happens when the Commission commences an inquiry? So as soon as practicable after commencing an inquiry, the Commission will give you a written notice setting out the grounds on which the inquiry was commenced. Before making any formal finding of non-compliance, the Commission will give you a reasonable opportunity to make oral and/or written submissions in relation to your compliance. The Commission may continue to engage with you voluntarily, or we may engage utilising our coercive powers. And again, the decision of how the Commission will engage will be impacted by the factors I spoke about earlier. For example, your compliance posture and history. So what coercive powers may the Commission consider utilising? So the Commission has powers to compel the production of information and documents during positive duty inquiries, as well as to examine witnesses by requiring a person to attend a particular place on a specific date and time to answer questions relevant to a positive duty inquiry. And it's important to note that it's an offence punishable by up to 12 months imprisonment if, in response to a notice requiring information and documents, that you knowingly give false or misleading information or produce a document containing false or misleading information. So what will the Commission do if it does find non-compliance as a result of an inquiry? So the Commission will notify you in writing and provide reasons for its decision. We may also provide recommendations for preventing the repetition or continuation of the non-compliance, and we may issue you with a compliance notice. So what is a compliance notice, and when would the Commission issue one? A compliance notice is a written notice issued under Section 35F of the Australian Human Rights Commission Act. A compliance notice may be issued if the Commission finds as part of an inquiry that you are not complying with the positive duty. Among other things, a compliance notice will set out brief details of the failure to comply and specify actions that you must take or must refrain from taking to address the failure. Again, the decision to issue a compliance notice will be impacted by the factors I spoke about earlier, such as your compliance posture, your history, severity of non-compliance, for example. So can you challenge the compliance notice? Well, the answer is yes, but it must be in writing. A person to whom a compliance notice is issued may, in writing, request that the Commission reconsider the compliance notice. The request must be received by the Commission within 21 days of the notice being given. And a person can also apply to the federal courts to seek review of the notice on the grounds that there has not been a failure to comply and/or the compliance notice itself does not meet certain necessary requirements. So what happens if you don't comply with the compliance notice? So the Commission can apply to the court to seek orders to enforce the compliance notice. If the court is satisfied that the compliance notice has not been complied with, the court can make an order directing you to comply with the compliance notice or any other order that the court considers appropriate. Now, you heard me earlier talk about the fact that the President of the Commission can also enter into enforceable undertakings. So what is an enforceable undertaking, which I will refer to as an EU? An EU is a legally binding agreement between an entity or person, such as an organisation or business, and a regulator, which is enforceable in court. So what kind of EUs can be given? EUs can be given to take certain action in order to comply, refrain from taking certain action, or to take certain action to ensure that you do not or are unlikely to contravene the positive duty in the future. So what factors does the Commission consider when deciding whether to accept an EU? So it's worthy to note that the Commission is not compelled to accept a proposed EU, and in making the decision, they may consider such things as, does it reflect meaningful commitments designed to achieve compliance with the positive duty? Will it assist with organisational reform? Will it assist in communicating the consequences of failing to comply and the opportunities and benefits of compliance? Again, the cooperativeness, the history and compliance posture of the organisation or business, if it's the most appropriate regulatory outcome in the circumstances, and the benefits of accepting the EU, including any benefits to the workplace, the industry, and the community. So can you vary or withdraw an EU? And the answer is yes. An EU can be varied or withdrawn at any time with written consent from the President of the Commission. Can an EU be cancelled? Again, the answer is yes. The President can cancel an EU by written notice to you without any requirement for your consent. So what happens if you breach an EU? If an enforceable undertaking is breached, the President may apply to the court for an order directing that you comply. The court can make the following orders: to direct you to comply with the undertaking, direct you to pay to the Commonwealth an amount up to the amount of any financial benefit that you obtain directly or indirectly, and that is reasonably attributable to the failure to comply with the undertaking. They can direct you to compensate any other person who has suffered loss or damage as a result of the failure to comply with the undertaking, or any other order that the court considers appropriate. So thank you. I hope that's provided you with an overview of the Commission's compliance and enforcement policy and its implications for organisations and businesses working to meet compliance. Caitlin, I'll hand back to you, or if there are any questions.
Great, thank you, Tanya. I'm just going to steer you back to the compliance approach pyramid. So we've had a couple of follow-up questions on it. The base of the pyramid is voluntary compliance. Above that, it shows informal resolution, a commitment to undertake agreed action. And then above that is administrative action, which is compliance notice and enforceable undertaking. Can you provide an example of when engagement may move from informal resolution up the pyramid to administrative action?
Sure, Caitlin. Look, of course, the easiest way to provide some context here is probably with some hypothetical examples. So one example may be when we've commenced an inquiry, we've attempted to engage with an organisational business we suspect of not being compliant with their positive duty obligations, and they're simply not willing to engage with the Commission on a voluntary basis. At that point, we may look to escalate the matter and use our coercive powers to compel them to give information and produce documentation as part of the inquiry, or even to appear at a certain time, date and place to answer questions. Another example may be where we've commenced an inquiry and the organisational business has been engaging with the Commission on a voluntary basis. And during the course of that engagement, non-compliance with the positive duty is identified, but the organisational business does not remedy the non-compliance voluntarily. At that point, we may seek to issue a compliance notice to compel that the non-compliance be remedied. A third example may be where we've commenced engagement on a voluntary basis, non-compliance with the positive duty has been identified, and the company does agree to remedy the non-compliance voluntarily and provide evidence that the non-compliance has in fact been remedied. But if the organisation or the business later fails to provide evidence or sufficient evidence to show that the non-compliance has been remedied, we may seek to issue a notice to compel that they give information and produce documents to evidence that, or we may even make them come and answer questions, or we may issue a compliance notice. So these examples aren't exhaustive, but they should provide some further context about why we may decide to move from voluntary engagement to a more coercive approach using our compliance and enforcement powers. And again, as you can see, this is reflected in the pyramid where our regulatory intervention may increase as cooperation from the organisation or business may in fact decrease. Thanks, Caitlin.
Great, thank you so much for answering that, Tanya. That brings us to the end of today's webinar. Again, thank you so much for taking the time to join us. And again, all of the resources mentioned in today's webinar are available on the Commission's website. We also have an information service. There's also information for that on our website. I will be sending around a follow-up email with the link to the recording of this webinar and with all the resources that we mentioned. So again, thank you so much for coming today, and please keep an eye on the Commission's website for any more upcoming positive duty events. Thank you.